Hello, my name is Bob Connolly, and I'm here to make a presentation on cartel enforcement in the United States, everything from leniency to perhaps prison. So I want to thank the Competition Law Observatory for letting me make this presentation, and thank you for listening. By way of background, I was with the Antitrust Division of the U.S. Department of Justice for 32 years, and just recently joined a law firm of DLA Piper here in the United States. So I hope I can share with you not only the written policies and procedures of the Antitrust Division, but also a little bit of the experience that I've had and how we actually, or they now, actually conduct investigations, what's important to them, and what some of their thinking is in some of these areas. In addition to this recording, I prepared a paper that will also be hosted on the website, and I did that because there are a lot of policies and procedures that I'll be referring to, and if you go to the paper, there are links to all these items that I'll be talking about in the course of the presentation. So the first thing I just want to say is when the Antitrust Division conducts a criminal investigation, we are really talking about hardcore cartel behavior, price fixing, bid rigging, and price fixing in the sense that there are meetings, there are agreements, score sheets. Most of the cartels that the Antitrust Division has prosecuted, especially the international ones, have involved fairly sophisticated means in the conspiracy. One of them that I worked on, Graphite Electrodes Cartel, there were top-level meetings and working group meetings. And these were the creative terms that the conspirators themselves gave these meetings. In other conspiracies, cartels, has been similar arrangements with different names. But the top-level guys get together and set overall objectives for pricing and try to work out differences if there's any big problems in the cartel. And the working level guys get together and they implement the volume allocation, keep the score sheet, and try to even everything up by the end of the year and make sure everybody's getting what they were allotted. So these are clearly hardcore cartels. A development in the United States that I'm sure everyone's aware of is just the increasing penalties for antitrust violations. When I did start in the Antitrust Division, it was actually quite a big deal. The first trial I had where the defendant was convicted, a U.S. executive received 6 months in prison. And that was a big deal then. It was often the case that people convicted didn't receive jail sentences. And that has changed dramatically over the years, not only in terms of what the statutory maximums are, has gone from a misdemeanor to a 10-year possible jail sentence for individuals during my career, but also in the application of what actually is imposed on executives. I remember a cartel case that I worked on where one of the foreign executives who was a subject of the investigation insisted on coming to the United States with his attorney and meeting with myself and the staff. And he asked, what could I do to put this investigation behind me? It was actually quite troublesome, I guess, to his company. And I said, well, you're going to have to plead guilty and spend time in a U.S. prison, and if you want to get the case behind you. And he was really quite put out by that suggestion. But eventually he did. And part of the reason is that foreign executives often cannot conduct business internationally if they're under indictment in the United States. And so that we do see more and more of the division's defendants being foreign executives who come to the United States, plead guilty, and serve jail time. I think in a recent auto parts investigation, the Japanese executive agreed to take 2 years in prison pursuant to a plea agreement. So the division is trying over time actually to even out the types of sentences that U.S. executives over whom it has jurisdiction receive versus foreign executives who do have the option of remaining fugitives. The sentences in the United States are governed by the Federal Sentencing Guidelines Manual. This is a copy here. Again, I have a link in the paper. But the reason in international cartel cases these sentences can get so draconian is the guidelines are basically a scorekeeping method. You get so many points for this, so many points if you fix prices versus bid rigging, so many points if you had a leadership role in the cartel. But the biggest driver of the guidelines is what was the volume of commerce. And in an international cartel, the AU Optronics case, what was the LCD panels, they recently went to trial and were convicted. Their volume of commerce in that cartel was over $2 billion, which puts them at the very top of the guidelines, puts all of their executives at the very top of the guidelines, allowing for a sentence up to 10 years. And that's from the most senior AU Optronics executive down to the most junior guy who may have just been at cartel meetings taking notes. So the sentences in the United States are serious, and they are escalating. Another subject, so how does the investigation get started? In the United States, the division always prefers, if possible, to start with search warrants. That is, when agents show up at a place of business or an individual executive's home with a warrant that allows them to search the premises and take certain records. A search warrant can only be gotten if the government agents go to court and present evidence of reason to believe that a crime, bid rigging or price fixing, has been committed, and that documents are located at a certain specified spot. So if an investigation starts with a search warrant, right away that tells you something. Somebody is cooperating with the Antitrust Division. It may be a disgruntled former employee. Most likely it's a leniency applicant, because the division has obtained this specific evidence of the cartel activity in order to justify to a court issuance of a search warrant. The other thing the division will do, actually before they conduct the search and maybe simultaneous with the search, where possible, if they have a cooperating witness, they'll conduct consensual monitorings. That's one party recording a telephone call. Or as they did in the Archer Daniels Midland case, they actually had videotapes of cartel meetings. The division will try to get as much information as it can through a covert means and then start an investigation with a search warrant. There are times, however, when a company only receives a subpoena. That is still means that they're in the sphere of the investigation. It's very onerous to comply with, but it also will mean that at that point in time, and this can change, the division did not have sufficient evidence against that company or those individuals to get a search warrant in court. And another thing that the division will try to do, along with competition agencies all over the world, and there are over 150 of them now, but the major competition agencies will try to begin an investigation when it's an international cartel jointly, so that the search warrants in the United States, they're referred to as dawn raids, usually elsewhere, will take place simultaneously or as near simultaneously as possible. Although on dawn raids, I'll mention we had a witness in one trial who was being cross-examined by the defense attorney, and he was questioning about the dawn raids. And the witness said, well, actually, I don't think dawn raids is the proper term. He says, we don't start anything in my country before 9 a.m. So, but in the United States and elsewhere, obviously, they can start as soon as they get actually authorization from a court. So the agencies try to coordinate, and the reason, again, is obvious. They want to preserve evidence to the extent possible. If there is a global cartel, and the United States goes ahead of anyone else, or Japan were to go first without coordinating, there's a serious risk of document destruction. And there's also, besides document destruction, what the agencies are trying to do is to create momentum, which they certainly get people's attention with dawn raids across the globe, and gain further cooperation. Like I said, they may have an amnesty applicant already, but they may not. But even if they do, they're looking for more cooperation. And sometimes, if the investigation starts with search warrants in the United States, there may not be parallel activity happening elsewhere in the world. Now, that will generally indicate that the evidence is limited to the United States. But a couple of things about that, and I'll talk about this a little more on another topic. That doesn't mean an investigation will not spread. It could either start in the United States, it could start in the EU, it can start in Japan, but competition authorities are talking to one another all the time, legitimately. In my experience, the agencies were scrupulous about not sharing information that they were not permitted to. In the United States, that could mean information gotten through a grand jury, information gotten from a leniency applicant, and in the EU and other jurisdictions, they have their own restrictions, and these are honored. But there is certainly other information that can be shared. And for example, if there were a leniency applicant in the United States and that company were involved in a worldwide cartel, the U.S. would not share that information with the EU or the Japanese or the Koreans, but the leniency applicant, just for good sense, may want to do so itself to get leniency in as many jurisdictions as possible where it thinks it has exposure. A very important topic is the view of the Department of Justice on obstruction of justice, document destruction, improperly trying to influence witnesses. And if an investigation is happening in the United States, the Department of the Antitrust Division will issue a subpoena. The subpoena will call for records wherever they are located in the world. So if there have been meetings abroad where there have been score sheets set up, price lists agreed to, attendance rosters, those kinds of evidence of a cartel, they will certainly be demanded in the grand jury subpoena in the United States. If they're located abroad, the United States Division cannot compel the production of those documents. But it is a terrible idea for anybody to destroy those records, because it is, in the United States, legally obstruction of justice if those records are destroyed, even if the destruction occurs overseas. And the basic idea behind that is, while the U.S. Cannot compel production of those documents, a company may ultimately, if not right away, at some point wish to cooperate and bring those documents into the United States. And you cannot bring in what you've destroyed. A interesting case study in this was the case against Ian Norris, who was a British executive. This is the indictment of Mr. Norris, which again is a link to it in the paper I provided. Mr. Norris was indicted by my office, and there was one count of price fixing, but there were 3 counts of what was a fairly elaborate obstruction of justice, both with what we call witness tampering and destruction of documents. And Mr. Norris was indicted for these offenses. Interestingly, it took a very long time for the United States government to extradite Mr. Norris from the UK, and Mr. Norris was not extradited to stand trial on the price fixing count, because at the time this occurred, price fixing was not a crime in the UK. He was extradited on the obstruction counts, because under dual criminality, that was also a crime in the UK at that time. So obstruction can also put somebody in a precarious position, more precarious position, for possible extradition. And another big reason why document destruction is always, in my opinion, a bad idea is today the company may not be seeking to cooperate. That may change tomorrow, depending on how things go in the investigation. And the best evidence that a company has to offer in cooperation, and the individuals with that company, are good records of the conspiracy. So if they've been destroyed, that is going to seriously limit the ability of a company to cooperate, or an individual, and the credit they'll get. And finally, I'll just mention from personal experience, nothing aggravates the enforcers, whether they're in the United States or elsewhere in the world, Nothing makes them a little bit more determined, a little bit more belief that a crime's been committed than if they get wind of obstruction. So it is just a very bad idea, even if all the activity occurs outside of the United States. The Antitrust Division in 1993 changed its leniency program and essentially changed cartel enforcement globally at that time. There was an old leniency program. Because it's old, I won't get into the details, but it was very, very, very rarely used. The current leniency program has been in effect since 1993. In one form or another, it has essentially been a model for other competition agencies around the world. And the idea is a simple one. It's cartels or secret crimes. In the States, we used to have an expression, and it may have originated elsewhere, but conspirators would say we could all hang together or we can all hang separately. And a lot of times they would hang together. And one of the devices that really made that more difficult was this leniency, which is the first company to come in and cooperate in an investigation will receive not only no fine, no criminal prosecution for the company, but the executives of that company who cooperate as well will not be prosecuted in the United States. And so, as I mentioned, the penalties, the fines, and the jail sentences are escalating up here, and at the same time, the inducement to cooperate is a complete pass, and it is very destabilizing for cartels. It is too good a deal for somebody to pass up if they've been involved in a cartel, and this can apply either when the division has no current investigation, but even if an investigation has started, it is now public. If no company has qualified for leniency at that point, and the division has not yet obtained all the evidence it needs to convict you, in the leniency is still available. The leniency program is fairly simple. First, in full cooperation, and full cooperation really means full cooperation. Some of these investigations can last a decade. That would be the outermost, but 5 years is not uncommon. So a leniency company is not only cooperating today, we're recording this in June 2013, they may be cooperating in June 2018 if there's a holdout in the cartel that goes to trial. It's full cooperation. And it has to be a complete corporate confession. Sometimes we would have the situation where a couple executives of the company would want to cooperate and qualify for leniency, but some very important people would hold out. They say, I'm in Europe or I'm in Japan, I'm retired, I don't want any part of this cooperation with the government. That would be a hang-up, and there'd be negotiations, and it typically got resolved. But it has to be a complete corporate confession. The company faces a big decision if you come into the United States to seek leniency. Because of the fines and the jail sentences, it's almost always going to be a good idea. But there are many, many things to consider, far beyond the scope of what I can talk about here. But again, they're in a paper that I've linked in a footnote to the paper I referred to. All the considerations that go into whether one should seek leniency. But it could generally be a bad idea if you're involved in an international cartel to seek leniency in the United States, but not the other jurisdictions where you have sales. Because if you don't get those leniencies, eventually somebody's going to. And then those jurisdictions where you didn't seek leniency are going to prosecute you. So a couple of quick points on the leniency. Over the years, the actual implementation of it by the division has led to a few refinements, terms that you may hear. One is affirmative amnesty. And if you hear leniency, amnesty, they're interchangeable in the U.S. But affirmative leniency is, and I did this in one investigation, we had good evidence of a cartel, but it wasn't enough yet to get a search warrant. And what we did was we approached, there was one very small company in the industry, and we approached them before we went public with the investigation and gave them a very limited time to do an internal investigation and decide whether to plead, whether to try to qualify for leniency. And they did. And that gave us the ability, A, to get search warrants, but another thing we were concerned about is we were glad that the leniency went to the smallest player in the industry. That's not often used, but that's affirmative leniency. Amnesty Plus is if there's an investigation and suppose your company doesn't qualify for leniency because somebody else has already got it, but you go into the division and work out a plea agreement on that product and disclose the existence of a cartel in another product. Amnesty Plus is you get amnesty for the second product, but you'll also get a pretty hefty discount on your fine for the first product. And Penalty Plus is just the reverse. You go in and you receive leniency on product A, but you're involved in cartels in several other products that you don't disclose to the division. And if the division eventually gets evidence of those other cartels and you have to pay a fine, that fine will be even more hefty because you didn't disclose it when you had the chance to get leniency. Industry mapping. I just want to mention this briefly because counsel should always be aware of what's going on in the world of cartels, because if there is graphite electrodes is a case, big international cartel that I worked on. And what we did there, and the division does this, I'm sure other competition agencies do this as well. So we had a conspiracy, and then we would take on a whiteboard, we would list all the companies, and then all the products that the companies were in. And then on these different product lines, who did they compete in? And we would have basically a tree of all the branches of that company's line of business. And so initially the investigation was on graphite electrodes. It spread to carbon electrodes, cathode block, isostatic carbon, various other related products that involved other companies. Some commonality, but then it would branch into other companies. So if you see an auto parts, the current auto parts, worldwide auto parts investigation is another example. It seems like every part in the automobile now is subject to investigation and prosecution, except maybe the air freshener that hangs from the mirror. But when that started with one product line, brake linings or brake drums, whatever it may have been, it would have been wise, and perhaps some counsel did this if they were in the automotive parts business, to do an internal investigation and see if they have a problem, because that has spread perhaps more dramatically than any investigation that I'm aware of with the division. So suppose you represent a company, you call it, you want to cooperate, you call the department, the division, and leniency's gone. So the division wants you to plead guilty. There is a lot to negotiate in a guilty plea. Especially the earlier you are in the investigation, the more cooperation the division needs, the more flexible they are on terms. And these terms of the plea agreement are not only important for the fine or the jail sentence that the company will get, but they become extremely important down the road with follow-on civil litigation. So terms like, well, who pleads guilty? Is it the parent? Is it a subsidiary? And it's big, important questions. Pleads guilty to what? What is the duration of the conspiracy? What products are involved in the conspiracy? What's the geographic scope? Some counsel have been successful in negotiating a plea agreement to fixing prices to a particular customer instead of the industry at large. These are extremely important terms, as I said, not just for the plea agreement itself, but the company will live with what it negotiates with the division for many, many years, live or die in civil litigation. The division has what they call a model. Division has a model for everything. They have a model annotated corporate plea agreement. And I say that with great respect. If you go to the Antitrust Division's website, I think it's terrific. The division tries to be transparent. What are their policies? How are they implemented? The model corporate plea agreement is listed there as well. A word about compliance programs. In the United States, and I think this is true in other jurisdictions, unfortunately, a company will get no credit for having an antitrust compliance program if they're being investigated or prosecuted for a cartel. They won't get any credit if they try to talk the division out of indicting them, and they won't get any credit for having the program in terms of what the fine or the sentence it is. And the division's rationale for this is simple. An antitrust compliance program is ineffective if referred to top guy meetings. Why should you get credit for an antitrust compliance program if the most senior management in the company are part of a cartel? So the division will not give credit. And the sentencing guidelines I referred to as well, they give credit for effective compliance programs. But again, if your senior management's involved in a worldwide cartel, they're deemed to be not effective. So there's no credit given for antitrust compliance programs. That being said, I think that compliance programs are extremely important and perhaps really neglected. FCPA or other corruption topics are the topics of the day, and rightly so. They draw a lot of resources in the area of compliance. But a price-fixing investigation can be just as, if not more, threatening to the life of a corporation and the senior executives of that company. So I think antitrust compliance program is extremely important, both for prevention, so that the company doesn't get involved in a cartel in the first place, or if that happens, if the company is involved in the cartel, an active compliance program may expose that cartel early on, which would, number one, limit the damages done by the illegal conduct, and secondly, put the company in a position to seek leniency. In order to get leniency, if counsel or the board of directors finds out that there's price fixing or cartel behavior in the company, they must take action promptly and effectively to stop that in order for them to be eligible for leniency. So, and on compliance too, I've over the years met with many executives, both U.S. and foreign, who have gotten involved in cartel activity, price fixing or bid rigging. And for whatever reason, they don't grasp the seriousness of it. They have their justifications why prices were terrible, we had to do something, our pricing was fair. They have their justifications. But what they go through, if they are the target of one of these investigations, is so serious. Business reputation shot. Families are often broken apart. And of course, in the U.S., real possibility of spending some serious jail time. So that I wish I could personally speak to every executive who may think about getting involved in cartel activity and just tell them some of the stories that I could tell them. And with that kind of training, they most assuredly would not. But it's just very important. Even though a lot of the industry, the bar, gripes because the division doesn't give credit, the sentencing guidelines don't give credit, I don't think compliance can be underestimated, maybe that's it. So, actually, when I give a live talk to a group, the number one question I'm usually asked is, are you almost done? And I can tell you I am. There's just one more topic that I'd like to cover. And so the investigation has begun. Another company has gone in and gotten the leniency. Companies B, C, and D have gone in and cooperated with the division, each with a plea agreement. And each plea agreement gets successfully tougher in terms of how many executives have to plead guilty, what are their jail sentences, what's the corporate fine, all these terms that I've talked about. The division gets more resolve the less they need the cooperation. And the reason the division can make deals with companies at some point in the investigation is under the guidelines, the division can make a motion to the court to depart from the guidelines in return for cooperation. So the division has the tools to induce cooperation by offering favorable plea agreement deals, but they get successfully tougher over time. But at some point, the division is no longer going to need cooperation. They're going to say, we have the evidence we need. There's nothing we have left to put our case together. And so the company may have little choice but to go to trial, because now they're faced with a guideline sentence. The guidelines are advisory, so a court can depart if there's certain good reasons. A court can depart from the guidelines, but the division will stand by the guidelines when it no longer needs cooperation. So anyway, what the division may be asking from in a plea agreement is very high, and a company and the individuals may say, you know, I have nothing to lose really by going to trial. And the division has a mixed record at trial. The division lawyers, I have all the respect in the world from good lawyers. They know antitrust law. They know the facts of their investigation, and they're a formidable adversary. But they have problems in trial. They have witnesses who have been immunized, witnesses who have gotten leniency, other very favorable deals, maybe a very short period of time. And these witnesses may have credibility problems in the eyes of the jury. Also, sometimes the division ends up in a position of more senior executives from Company A are testifying against more junior executives who are on trial from Company B. And juries may not like that. So there are other issues. I've tried the cases where, you know, the witnesses have a cooperation agreement with the government to tell the truth, the whole truth, but they're testifying against friends. And it can be very difficult to get information out of them. So the division can have problems at trial. On the other hand, they can also have tapes. They can have very hot documents. They can have many witnesses. And so they can overcome a lot of problems as well. So every case has to be judged on its merits. Some are triable. Here's a good example of this I guess, dilemma a company faces in AU Optronics. It was a recent trial. The division, this is in the LCD display panel cases, the division, AU Optronics was apparently the last company in. The division indicted the Taiwanese company, the U.S. subsidiary, and 9 executives. And then under the guidelines, the sentences the division wanted pursuant to a plea agreement were extremely high. So AU Optronics went to trial. The company was convicted. Not all 9 defendants were on trial, but some were. 5 were. The company was convicted. Of the individuals, 2 were convicted, 2 were acquitted. You can't get acquitted unless you go to trial. And 1 had a hung jury, and he was subsequently convicted in the retrial. And so there's been debate, over who won this case. And the division, of course, has a good claim to victory. They proved the conspiracy. They convicted the company and its senior executives. And it was the first time ever that the division proved to a jury, beyond a reasonable doubt, that the damages from the cartel were $500 million, which under an alternative fine sentencing provision of the United States, the Sherman Act maximum is $100 million, but if you prove the gain from the cartel, the loss to the victim, a court can impose double that. So the division proved $500 million in loss, beyond a reasonable doubt, to a jury. This was a very important victory for the division. So the division claimed victory. On the defense side, as I mentioned, 2 people were acquitted. And the division wanted a fine of $1 billion, twice the loss. The court only imposed a fine but it was $500 million. And the division, under the guidelines, wanted jail sentences approaching 10 years for the indicted executives who were convicted. And the court imposed sentences of 2 and 3 years. So from the defendant's perspective, they did better off by going to trial. And, of course, 2 of them were acquitted completely. So that's it on cartel enforcement in the United States, from beginning of investigation right up through a trial and possible prison sentences. It covered quite a few areas in just a very general overview, so I hope it was informative. And if there's any questions that come out of it, I guess my email address is available, and I'd certainly welcome discussing them with you. So thanks for your attention.